So let's talk about HOAs, homeowners associations. How much power do they really have? Can they actually dictate how you show your patriotism? Well, we're about to find out, because we're diving into the story of one Arizona family whose simple request to fly two flags, one for the U.S. and one for the Marine Corps, ended up sparking a huge legal battle that went all the way to court.
I mean, it's the classic homeowner's dilemma, right? You buy a home, you agree to the rules, but then what happens when those rules clash with something you feel really passionate about, like flying the American flag? A case out of Sun City, Arizona puts that very question to the test, and believe me, the answer might just surprise you.
At the very heart of this case is a woman named Joyce Monsanto, and for her, this was deeply personal. Her husband served 25 years in the Marines. One of her sons served 25 years in the Marines, and another son spent 30 years in the Coast Guard. The court findings themselves actually describe her family as very patriotic. So you see, when she made her request, it wasn't just about decorating her home. It was about honoring a lifetime of service.
Okay, so let's start at the beginning with the simple request that kicked this whole thing off.
It all started back in August of 2018. Mrs. Monsanto puts in a request to install two 6-foot flagpoles on her house, one for the American flag and one for the Marine Corps flag. Now here's an interesting little detail. Her official reason wasn't about patriotism. It was about aesthetics. She just thought two poles looked better. Well, about a month later, the HOA's architectural committee came back with their decision, a firm no.
So what was the big deal? Well, the HOA's whole justification came down to one simple line in their guidelines: one house, one flagpole. This wasn't a ban on flying flags, but a limit on the number of poles. And that tiny distinction is what this entire legal fight would end up hinging on.
And this is where things get really interesting, because we're moving from a simple neighborhood disagreement to a full-on legal showdown. It wasn't just about one person's preference versus the HOA's rulebook. It was about whether that rulebook was even legal under state law.
Now, before we go any further, just a quick definition. When we talk about HOA rules, we're talking about the CC&Rs. You can just think of it as the official constitution for a neighborhood. It's a legally binding document that everyone agrees to follow when they buy a home there.
So here's where the law and the rulebook just smash into each other. On one side, you've got Arizona state law. It's really clear. An HOA shall not prohibit you from flying the American flag or a military flag. But, and this is the key, it can set reasonable rules about how you fly them. On the other side, the HOA's rule is super simple: one flagpole per lot. So the entire case really boiled down to one question. Was that one pole rule a reasonable regulation, or was it an illegal prohibition?
So, after that initial denial, Ms. Monsanto takes her case to the HOA board. And suddenly, the fight isn't just about the flagpole anymore. It becomes this whole battle over the appeal process itself.
Let's just walk through the timeline. On October 1st, she files her appeal. 2 weeks later, she's told it'll be discussed at the November 8th meeting. That meeting happens. Then almost a month goes by before the draft minutes get posted online saying her request was rejected. On the surface, it seems pretty straightforward. But what actually happened at that meeting? Well, that was anything but.
And the answer to that question, it really depends on who you ask. The November 8th meeting became this classic case of he said, she said, and it was up to an administrative law judge to try and sort out the truth.
On one side, you had Ms. Monsanto. She testified that the board never even discussed her appeal, and she left without any kind of decision. On the other side was the HOA president, Anthony Nunziato. He swore he was certain they considered it, and that he personally told her verbally, right then and there, that the appeal was denied. You've got two people with two completely different stories about the exact same event.
So, with these conflicting stories and clashing rules, the case finally landed in front of an administrative law judge. After looking at all the evidence, she made her decision.
First up, on the main issue of the rule itself, the judge sided with the HOA. The rule limiting homeowners to just a single flagpole was officially deemed reasonable under Arizona state law.
Now, the logic behind that is really crucial. The judge basically said that the HOA was not prohibiting Ms. Monsanto from flying her two flags. They were simply regulating the way she could display them. Since she was still totally free to fly both the American flag and the Marine Corps flag on a single pole, her rights under state law weren't violated. Okay, so what about that messy meeting? Well, once again, the judge sided with the HOA, finding that their denial of the appeal was totally valid.
This one really came down to who the judge believed.
The ruling says flat out that the HOA president's testimony was credible. So, the judge concluded that the board did make a decision, and they did tell Ms. Monsanto at the meeting. And those online minutes that were posted later, that was a good enough written record. And this quote, which comes directly from the judge's conclusion, really just captures the whole thing. The judge framed this entire fight not as a battle over patriotism, but as a conflict between a personal aesthetic choice and established community rules. And in the end, aesthetics lost.
So why does this one case in one Arizona neighborhood even matter? Well, let's break down the key takeaways for any homeowner who lives under an HOA.
So what did we learn here? First, while the law protects your right to fly a flag, your HOA can still set reasonable limits on how you do it. Second, that word reasonable can be interpreted pretty broadly, right? In this case, it meant limiting a homeowner to just one pole. Third, procedure really matters. The HOA won partly because the judge believed they followed their own process. And finally, remember this. Your personal taste probably isn't going to beat a clearly written rule. Because it looks better is just not a great legal argument.
Ultimately, this case leaves us with a huge question that every planned community has to deal with. We all agree to follow rules for the sake of harmony and property values, but at what point do those rules go too far and step on our personal expression? It's a balancing act, and there is no easy answer.